Hi, everyone. Welcome to the EU-Asia Aviation Law Forum. My name is Woon. I am Assistant Professor at the Faculty of Law in the Chinese University of Hong Kong. We call it CUHK Law. This event is jointly organized by our Center for Comparative and Transnational Law and the Center for Commercial Law Studies in Queen Mary University of London. The idea of EU-Asia Aviation Law Forum was emerged when I was speaking to Dr. Antigoni Lykotrafiti from Queen Mary University of London. I've known Antigoni for several years, since 2014, when she was working for OECD. Post Antigoni, I thought that it would be meaningful to have a regular forum to engage in debate on aviation law issues in the EU and Asia. Your participation makes me think that we were right. We have participants from various aviation authorities in Asia, the airlines and law firms, and many university academics and students from China, UK, India, Philippines, Thailand, Pakistan, Bangladesh, and Canada. Sorry for the wrong time in Montreal. Also, of course, students and alumni from CUHK Law and Queen Mary University of London. Thank you for your support. I will now speak about the structure of today's forum. In about 3 minutes, Antigoni will first present on EU single aviation market for about 15 minutes. Then I will speak about ASEAN single aviation market for 15 minutes. Then Mr. Máté Gergely from European Commission will speak about EU-ASEAN Comprehensive Air Transport Agreement for 20 minutes. Of course, EU-ASEAN CATA Comprehensive Air Transport Agreement is the main topic of today's event. But we thought that after having heard from EU and ASEAN single aviation market, audience can get to the EU-ASEAN CATA in a more familiar way, in a more structured way. After Máté's presentation, we will have an internal discussion for about 10 minutes, meaning Antigoni, me, Máté will talk about 10 minutes. Then there will be 15 minutes afterward, 15 minutes Q&A session from the floor. So if you have any question, you can leave your question in the chatting box, and Antigoni will moderate the Q&A session later on. So now, let me briefly introduce speakers. First of all, Máté Gergely. Máté is an expert in international air law and policy. He has many years of unique work experience in the airline industry, government, and international organizations. He started his career in the law firm in Budapest, Hungary, in his home state. He was Prime Minister's office as a legal advisor and cabinet of Minister of Transport. He was a legal counsel at the MALEF, then flag carrier of Hungary. Since 2023, Máté has been working for EU Commission's Director General for Transport, now DG Move, except few years. He served as Director General for Civil Aviation in Hungary, and as well as senior expert in economic regulation and ICAO, International Civil Aviation Organization. Since 2020, he's been working as Aviation Security Unit of DG Move. But I got to know him, I have to say that I got to know him by his academic article. So it shows that he is quite active in academic work. I'm the second speaker. I don't have much to say. One thing I want to say is that I supervise PhD students. So if you have any plan to work as PhD in the area of aviation law, please contact me. Our first speaker is Dr. Antigoni Lykotrafiti. Antigoni is a lecturer in transport, energy, and law at the Center for Commercial Law Study at Queen Mary University of London. Prior to joining Queen Mary, she worked for OECD on transport policy issues. She was a previously assistant professor at Tilburg University and Jean Monnet postdoctoral fellow at EUI, and also practitioner in leading law firm. She specialized in European law, international law, law and economics, and law and innovation that can be applied to air transport. Those who want to know about fair competition in international transport, her article on 2020 Common Market Law Review is a must-read article. I strongly recommend it. All right, ladies and gentlemen, we are now ready for takeoff. Antigoni will speak about EU single aviation market for 15 minutes. Over to you, Antigoni.
Thank you very much, John, for this very generous introduction. I would also like to welcome everyone on board, and I hope that it will be a very interesting and useful webinar. Today's joint webinar between the Chinese University of Hong Kong and Queen Mary University of London. And as you have already said, I will present on the EU single aviation market before giving the floor to you to elaborate on the ASEAN single aviation market. So before looking at the single air transport market in Europe, I think it's worthwhile looking at European integration. We all know of the European Union. We all know that it is about political integration, but we didn't start out as a political union, and I use first person since I am a European national and admittedly a Europeanist myself. So in the aftermath of the Second World War, we had the European coal and steel community, and coal and steel are commodities necessary in warfare. So the idea behind that community was that another war would be prevented in Europe. And from the European coal and steel community, we moved to the European economic community, and that took place in 1957 with the Treaty of Rome. And already at that stage, when the Treaty of Rome was adopted, the institutional apparatus was there to pave the way for regional integration and for political, arguably, integration, i.e. the European Commission was already established, the European Court, the Council of Ministers, and the European Parliament, which at the time I think was called Parliamentary Assembly. Another milestone in European integration is the Single European Act, 1986. It is important for many reasons, including because it sets the year 1993 as the cutoff point by which a single market should have been created in Europe. And indeed, on 1st January 1993, in Europe, there was a single market. A very important milestone in European integration is the Treaty of Maastricht in 1992, which created the European Union, which is now a political union. So from economic integration, from an economic community and the customs union with free movement of goods, we moved on to a European Union with freedom of establishment, free movement of goods, persons, capital, services. And another milestone in European integration is the Treaty of Lisbon, which entered into force in 2009, in November 2009. It is important because it explicitly recognized the legal personality of the European Union, which means that the European Union can become a member of international organizations, it can conclude and negotiate international agreements, and it can join international conventions such as the European Convention on Human Rights. Looking now at the application of EU law to air transport, it wasn't clear from the outset that the Treaty on the Functioning of the European Union, this is the Treaty of Rome as amended, was applicable to aviation. In the treaty, in the founding treaty of the European Union, there is a chapter on transport. And if you read the first provision, it provides for the creation of a common transport policy. But if you read at the last article of this chapter, it provides that the European Parliament and the Council may lay down appropriate provisions for air transport. So somehow it appears that rules on aviation or a common aviation market is contingent on prior action by the Council. So for many years in Europe, there was it wasn't clear, there was controversy as to whether aviation was excluded from the treaty provisions on transport or from the treaty as a whole. And this is when the European Court of Justice was called upon to adjudicate on these issues, including on the application of competition law to aviation. And in a series of seminal judgments adopted from 74 to 86, the court clarified, the European Court of Justice in Luxembourg clarified that aviation is subject to the treaty on the same basis as other modes of transport. And this paved the way for the European Commission to push ahead with liberalization. So the court's rulings really enabled the European Commission to take the helm. Early on, the European Commission, already in the late 70s, it had adopted a memorandum, an aviation memorandum, and 79 is just a year after domestic deregulation in the United States with the adoption of the Airline Deregulation Act. So already in 79, the European Commission was asking for a European air transport policy. And in 81, it was already considering the creation of an EU external aviation policy, something that the Council at the time was not particularly keen on. However, the court's rulings persuaded the Council to adopt 3 packages of air liberalization measures. The first was adopted in 87, the second in 1990, and the third entered into force in 1993. And these are hard law instruments or regulations, decisions, directives, and they liberalize the domestic air transport market. The freedom to provide cabotage was offered to EU airlines in 1997, and this is when liberalization was complete. So you see that liberalization in Europe was progressive. We adopted a staged approach. We started in 1987, and in 1997, there was the establishment of a single aviation market in Europe. Obviously, liberalization raised a number of issues that have to do with competition, that have to do with level playing field. If you look at the 1994 Aviation Guidelines, and this is the first set of guidelines on aviation that the European Commission adopted, it is a soft law instrument. They are about rescue and restructuring aids to ailing national flag carriers. At the time, so when liberalization was almost complete, the issue was the national flag carriers. The problem in Europe was illegal state aid granted to ailing national flag carriers. Europe's airlines, which had been state-owned, most of them were state-owned, they were heavily subsidized. And so liberalization entailed the need to phase out illegal state aids. And we had the first set of guidelines that provided guidance to national governments. In 2005, we had a new set of guidelines, and by that stage, most of the European airlines, they had restructured their operations, they had returned to profitability. Some of them had exited the market. For example, Sabena, the Belgian airline, went bankrupt in 2001. And in 2005, the issue was low-cost airlines and whether low-cost airlines get subsidies from regional airports to start up operating out of these airports. So the 2005 guidelines focused on low-cost carriers, which are, of course, children of deregulation, children of liberalization. And airport financing had also entered the equation in 2005. So the focus now is shifting towards airports. And this became clear with the adoption of the 2014 Aviation Guidelines, which are basically concerned with investment aids to airports. So airport infrastructure and the conditions under which governments can finance airport infrastructure. Here in the UK, 50% of airports are private, have been privatized, and there is a similar trend in Europe. So the issue is whether the airport operator must finance the investment of the infrastructure or whether the government can contribute as well and under what conditions. The establishment of a single European aviation market entailed the transition from national airlines, i.e. from the transition from airlines which were nationally owned and effectively controlled by the member states where they were established or by nationals of that member state, to EU airlines, i.e. airlines which are majority owned and effectively controlled by EU nationals. And of course, it also entailed freedom of establishment. The problem, however, was that the member states, when entering into air services agreements with third countries, they negotiated nationality clauses, what we call ownership and control clauses. And these ownership and control clauses enable the contracting parties to block the designation of airlines which are not majority owned and effectively controlled by the other contracting party. And so when the US launched its open skies policy in 1992, a number of EU member states entered into open skies agreements, and in these air services agreements, there were traditional nationality clauses, which gave the possibility to the United States, the privilege to the United States, to block the designation of an airline which were not majority owned and effectively controlled by the EU member state that had designated. But in Europe, as I said, we had already moved from the notion of a national airline to the notion of a European airline. And so the European Commission brought infringement proceedings against the member states, the EU member states that had entered into open skies agreements with the United States before the European Court of Justice, which had to adjudicate on whether the EU has exclusive external competence to conclude their service agreements with third countries, which is what the Commission was claiming at the time, and on whether the ownership and control clauses violate the freedom of establishment. The court, in its open skies judgments, answered this question, and the court found that the EU does not have in principle exclusive external competence to conclude air service agreements with third countries, which means that the EU member states have not given up on their sovereignty in this area unless the European Union has been mandated, an institution of the European Union, in particular the Commission, has been mandated to negotiate on behalf of the member states, in which case the European Union does have exclusive competence. And in the areas where the EU has harmonized its law, and in the areas where the EU has adopted internal rules relating to the treatment of third country nationals, in these areas the EU does have exclusive competence, and the member states, when negotiating with third countries, must make sure that they do not violate, they do not agree something that is that encroaches on these provisions. And finally, the open skies judgments of the European Court of Justice enabled the Commission to develop its EU external aviation policy, which is based on three pillars. I will focus on the second and the third pillar because this is what we are going to discuss today. A main pillar of the EU external aviation policy concerns the conclusion of comprehensive air transport agreements with key partners. And you see that the terminology has changed because we used to refer to agreements as air services agreements. So it is all about, or it used to be all about air services, exchange of traffic rights, market access, pricing, regulation of issues such as capacity and frequencies. Here, the term is broader. These are air transport agreements. So they cover also, they regulate also other issues that have to do with fair competition, that have to do with subsidies, that have to do with the environment, with passenger rights, with social issues, etc., etc. This is why the European Commission refers to them as comprehensive air transport agreements. And of course, such agreements aim at market opening as well as at fair competition through regulatory convergence. So regulatory convergence is a buzzword, really. And the EU has negotiated comprehensive air transport agreements with the US, with Canada, recently with Qatar, and it has concluded the negotiations of a comprehensive air transport agreement with ASEAN. I believe the agreement is now subject to legal scrubbing, and hopefully it will soon be signed and ratified. And another pillar of the EU external aviation policy concerns the creation of a common aviation area with neighboring countries. And again, what we want to achieve is gradual market opening and regulatory convergence towards EU aviation legislation. So the European Union asks its neighboring countries to harmonize its law, or to make sure that its law on certain areas such as competition, environment, subsidies, etc., is in line with EU law in exchange for free market access into the single European air transport market. And the European Union has concluded comprehensive air transport agreements with countries in the Western Balkans, with Morocco, with Georgia, with Jordan, Moldova, Israel, Armenia, and Ukraine. And it is impossible really to pronounce the name of this country today without paying tribute to the Ukrainians who fight for the liberation of their country. And the agreement between the EU and Ukraine was signed on the 12th of October 2021, and it is in provisional application. And I believe it brings Ukraine a step closer to the European Union. And I will leave it at that, and I will hand over to Woon, who will deliver his presentation on the ASEAN single aviation market. So thank you.
Thank you, Antigoni. Really insightful, informative presentation. I also appreciate your on-time performance. So we, as you agreed, we've done 15 minutes. And now I'm going to do my job, which is the ASEAN single aviation market. Let me do it now. Okay, just want to check. Do you see the full screen? Can you confirm?
Yes, Juna, we can see your slides, yes.
Okay, thank you, thank you. All right, so for the next 15 minutes, I also see the reaction from my students. Thank you so much for that. So ASEAN single aviation market, I'm going to talk about this one for the next 15 minutes. And it's also good to have the Antigoni's presentation first, because ASEAN learned a lot from EU in the process of making single aviation market. But at the same time, I really want to emphasize from the very beginning, EU single aviation market is very exceptional. It is right, it's a good model when it comes to single aviation market, but EU single aviation market is very highly exceptional compared to other parts of regional aviation market, including ASEAN. So before talking about aviation, I want to bring your attention to the diversity of ASEAN. I mean, I understand that many of you are from Europe, so maybe you are not even geographers. So ASEAN is about association of Southeast Asian nations consisting of 10 different countries. So from Myanmar, from the north to Indonesia to the south. What I want to emphasize is again, diversity. So here, if you look at the GDP, gross domestic product, Indonesia by far the largest country in ASEAN. If you look at the per capita, then Singapore, Brunei are the one. If you compare to others, really the gap is significant. In terms of aviation, what I want to emphasize is the volume in domestic and international traffic. So this is the one written by Harris Juan. And if you look at this one, domestic air passenger traffic and international air passenger traffic, some countries are nicely balanced. I would say Malaysia are really almost like same level. Vietnam. So that means what? You have a strong domestic market as well as strong international market. If you look at the Brunei and Singapore, obviously they do not have domestic traffic. So, and you also have countries where domestic volume is bigger than international, so, such as Indonesia. So if you look at Indonesia domestic air passenger traffic and with Singapore international traffic, Indonesian domestic traffic is bigger. That really means something. You know, as I'll explain later, they have more to share. They have more to offer in terms of air traffic rights. So this size, the vast difference among those ASEAN states, really make an implication in the ASEAN single aviation market. So what happened and what about ASEAN single aviation market? That it basically consists of three major agreements. These are 2009 multilateral agreement on air services, 2010 passenger, 2009 cargo. But the idea of ASEAN single aviation market was started in 2004 when ASEAN Transminister started to discuss, and they adopted action plan for ASEAN air transport integration. So this is one difference. If you compare with the EU, as Antigoni will explain, it started from the top. The EU wanted to be a single market, and part of it, aviation was one of the market. Aviation, single aviation market in ASEAN was not coming from that way, was not coming from top down. It started from more sector-specific integration, starting from 2004. The roadmap has been successfully incorporated into three formal legal agreements. So once again, under these three major agreements, there are various protocols. Before I explain those protocols, I need to explain a little bit about freedom of air. I'm sure many of you in this room are familiar with this, but for those who are not familiar with this, just just 2 points. When you say third and fourth freedom, this is the traffic between your origin to destination, passenger. So when I depart from Hong Kong, you go to Tokyo, come back, this is third and fourth freedom. So traffic right received by your respective government, and you can depart from your home state, then you come back. Fifth freedom is something beyond that. You go to first foreign country, and you continue to go to another foreign country. So the right that you can transfer between this, for example, here, Vancouver to New York by Hong Kong registered airline. This is the fifth freedom. And this has been always controversial. This fifth freedom has been always controversial in air traffic right. So in the 2009 MAS, the protocol 1 to 4 doesn't really carry meaningful weight. But what's important is protocol 5, protocol 6. Here, we're talking about unlimited third and fourth freedom. That means traffic between Hong Kong is not an ASEAN, Singapore to Kuala Lumpur, Bangkok to Jakarta, that is unlimited as long as they operate by their own national carriers. Protocol 6 is about unlimited fifth freedom. So that means, from Jakarta go to Singapore, and Singapore go to Bangkok. That's possible. But you also need to, although it sounds very nice, you need to think about the background, which is geography. Not many people would go to Bangkok via Singapore from Jakarta, because we are only talking about 4-hour flight. If you are flying from Jakarta in the south in ASEAN to north in Myanmar, it's about 4 hours. You don't want to transfer in this short flight. So that means fifth freedom, although it sounds nice, internal fifth freedom in the ASEAN doesn't really carry significant commercial value. That I have to emphasize. The 2010 passenger full liberalization, it covers the remaining passenger the transportation, except the one I mentioned in 2009. In other words, there are a lot of destinations in ASEAN. There are a lot of popular destinations that are not capital. Bali, Ho Chi Minh City. These are, Penang. These are few examples that they are not capital city, but still popular destination in ASEAN. So 2010 Malful Pass, I can't pronounce perfectly. It discussed the full liberalization, again, third and fourth freedom, the traffic between those three. That's about protocol 1. Protocol 2 is about fifth freedom. What is interesting is that from 2018, ASEAN started to adopt a little further, which is protocol 3 and 4. Here, we're looking at domestic code share right between point within territory of another ASEAN state, or co-terminal right. I don't want to go too much detail, but co-terminal right means that the foreign aircraft can go to give you an example. Singapore Airlines can fly to Jakarta and may continue to go to Bali, but they cannot take a passenger from Jakarta. You can go to from Singapore, stop and Jakarta, and then you go to Bali. But that right, the right that you can transport in the one country without taking traffic, that is post-terminalization. It gives some flexibility for airline. A Protocol 3 and 4 adopted under 2010. What is interesting, Indonesia has not signed, and there's no sign that Indonesia will ratify Protocol 3 and 4 in the near future. So it's still all 9 states except Indonesia are parties to Protocol 3 and 4. I'll be brief on this one. This one is more about cargo, and it has been concluded up to fifth freedom. Again, internal fifth freedom. So in a nutshell, ASEAN single aviation market has achieved up to fifth freedom or sixth freedom. Sixth freedom is a combination of a third and fourth freedom. So up to the sixth freedom, that's done. There is discussion about seventh freedom, ninth freedom, eighth freedom, but there's no sign that it will be signed, implemented in the near future. Obviously, European single aviation market achieved up to ninth freedom that include cabotage. So in Europe, Air France can transfer from Barcelona to Madrid. That is perfectly fine, allowed. That is eighth freedom or ninth freedom, depending on where you start. The next topic I want to address is that also Antigoni mentioned the right of establishment. Ownership and control restriction is quite unique one in the airline industry. That's basically a foreign investment restriction. So your own airline must be substantially owned and effectively controlled by your own national. It could be government, it could be your own national, people, but foreign ownership must be limited up to 49%. Most countries are taking that at least majority ownership and effective control must be done by your national. EU erased it, removed it, changed it from nationality based to community based. So as long as airlines are set up by European investment, that allows it. So European country allows the European national investment. ASEAN wanted to learn from it. Their language quite similar, but it's not the same. There's a veto power if in a nutshell, the foreign investor, even the ASEAN investor, they cannot set up 100% own airline in the one of ASEAN members if that state objected. Instead, what we have seen in ASEAN is sort of, I would say, collateral benefit. We have seen a lot of joint venture airlines. Antigoni mentioned that the importance of LCC in the context of liberalization. Quite similarly, in 2004 and 2005, that's time the ASEAN also started to have LCCs, low-cost carriers. And I'll go back to this slide later, but this is an old picture, but for long enough time, I mean, there are many LCC. There were many LCC. Many airlines disappeared for in the process of COVID-19, but different subject, different topic. But before COVID-19, there were many LCCs, and many LCC were actually joint venture airline between the two ASEAN states, the investors. So to name a few, in the left, the name of airlines, they are registered in this country, but their overseas partners is other ASEAN member states. So although ASEAN didn't change law, somehow policy aspect, effective control has been relaxed so that they were joint venture airline were able to set up in the other neighboring ASEAN countries. I call it this is a collateral benefit coming from regional liberalization approach. So here again, EU broke this tradition by introducing community carriers. ASEAN, no, it's not allowed, but joint venture formed by two different ASEAN countries, it has become commonplace in ASEAN. So Antigoni also mentioned the external aviation policy. And it's interesting that ASEAN started this external aviation policy before concluding their own internal integration. They really started from the very beginning before they concluded fifth freedom integration. So for at least because they thought that it would have a sort of competitive advantage when they start to negotiate with other partners. They started to talk to China, Japan, Korea, India, recently the EU, which will be covered by Máté. And they started the discussion, but the only agreement we have so far is the agreement between ASEAN and China. It has been signed to 2010 and the protocol and 2010-2014. I have to mention that the reason why the ASEAN-China air transport agreement was concluded 2010 is because there was sort of discussion between FTA. China and ASEAN agreed that they want to conclude FTA in conjunction with air transport agreement, which they did it. So when they signed FTA, free trade agreement, they also signed air transport agreement. Obviously, we have the key topic, which we covered, ASEAN-EU comprehensive agreement. Even China, and the reason why ASEAN-Japan, ASEAN-Korea air service agreement is not really working well is because of fifth freedom. I mentioned the controversial aspect of fifth freedom, because what ASEAN wants is unlimited fifth freedom. That means Singapore Airlines wants to fly to the United States via Incheon, Seoul, or Tokyo, unlimited. So in theory, if this Korea-ASEAN Open Sky Agreement is signed, they can send 10 flights per day from Singapore, and then from Seoul to New York, Chicago, LA, many destinations in US. That is not accepted by Korean government. So fifth freedom is the reason why Japan and Korea couldn't sign air transport agreement with ASEAN yet. So final slide. So this, in my book chapter on ASEAN, I said that slow but good progress. I'm not criticizing slowness of ASEAN. I'm actually praising ASEAN because despite the difficulties, political difficulty and reality, ASEAN was able to achieve significant progress in aviation market. But it has to, if they want more, it probably has to come from the top. It depends on political will. So here in 2025 ASEAN Economic Committee Blueprint, there's some phrase about air transport. It says strengthen ASEAN single market for more competitive, resilient ASEAN through the following key measures, including foster greater connectivity with other dialogue partners. So it really depends on political will in terms of the ASEAN single aviation market. With that, I think I had one time. Over to you, Máté.
Thank you, June, Antigoni, and everybody. Good morning or good afternoon, depending on where you are. Let me share my screen. Just a moment. Just wanted to say that it will be easier for me because some of the key concepts have been already introduced by Antigoni and June.
Máté will speak today in his personal capacity, so the Commission is not bound by what he's going to say, but his insights are important because he has a lot of experience having worked, as June mentioned, for his national government, for a supranational organization, the European Commission, an international organization, the International Civil Aviation Organization, as well as the industry, MALEF, and so we are really looking forward to Máté's presentation.
Yes, this one. So I would like to contribute to this discussion on the EU-ASEAN Comprehensive Air Transport Agreement by trying to tell you why this approach of the CATA negotiated by the European Union is an innovative approach. But when we say innovation, of course, we have to find something to compare with. And we compare this approach with the traditional air services agreements, so the bilateral air services agreements, which are still out there in thousands, and they are still the basis for international air transport. So it's we can always say they are outdated or traditional, whatever, but in reality, they are still the backbone of the regulation of international air transport. And one important element in the EU-CATA approach is that instead of these bilateral agreements, and there are actually dozens between EU member states, individual EU member states and individual ASEAN states. So instead of this patchwork, the CATA establishes one framework. So there will be one regulatory framework for all the air transport services between the two blocks, the EU member states and the ASEAN member states. Now, in the EU CATAs, we can observe the ambition to reach a high level of liberalization, and not only in market access, but also in ownership and control. I will say a few words about that. And it was mentioned already, there's a strong focus on regulatory areas, all actually areas of civil aviation. So that's why we call them comprehensive. And this includes fair competition, which is basically missing in the traditional air service agreements. And finally, I will say a few words about the institutional inventions as well. And I would like to say it's important that unfortunately, we do not have the EU-ASEAN agreement publicly available yet. So as the best example of analogy, I have used the EU-Qatar agreement, which was signed last year, and that is publicly available, so you can all check against this one. Next slide, please. So first of all, the EU CATAs always follow a regional approach. That means that they cover the European Union and all its member states. And why we say all is that because, as Antigoni explained, there is the difference between competencies of the European Union and the member states. And there are basically three areas. There are areas where the EU is has exclusive competence, for instance, competition law. Then there are so-called mixed areas where both the EU and member states have competencies, so they share these competencies. And of course, there are some where member states retain their competence. So these agreements cover so many areas that we call them mixed. So instead of only covering member state competencies, which the traditional air services agreements did, they also cover EU competencies. So that's why the contracting parties must be the European Union and its member states. And I mentioned already that the bilateral agreements, legally speaking, are superseded once the CATA enters into provisional application at least. Next slide, please. So liberalization is a key element of the CATA approach. And I would start with the route rights and traffic rights. And of course, it depends on the actual agreement we are looking at, because of course, they are all the outcome of negotiations. So it depends also on the partner country or countries in this case. But what we can observe in general is that there's completely free routing. So airlines can fly on any route. And also there are unlimited third and fourth freedom rights in passenger transport. So point-to-point services are completely liberalized. And as June, you said eloquently, indeed, fifth freedom can be a sensitive issue in passenger transport especially. And here the EU approach is more, I would say, cautious or conditional, and depends a lot on the partner state. What we can see now already from the information available about the EU CATA with ASEAN is that there will be indeed some limitations on the fifth freedom passenger rights, 14 in the beginning, but we can expect that this will be gradually increased in the course of the implementation of this agreement. Yes, this brings me to the next one, which the gradual nature of liberalization, which we can see in many of these agreements. Why gradual? Because if the partner state is not ready to go for an immediate liberalization, then there is always a good way to kind of phase in the liberalization gradually, either time-wise or maybe with some conditions. And that is very useful actually, because it sets a framework for a progressive liberalization in the medium or longer term. And finally, when it comes to air cargo services, it's very important that there normally the liberalization is much more straightforward, with no limitation on traffic rights, whether it's third and fourth or fifth, or in some cases even higher traffic rights. Next one, please. Thank you. So the EU has also a liberal approach towards airline ownership and control based on the good experience in the internal market. And so normally they offer some kind of liberalization approach when negotiating the agreements, but this is a very sensitive area for reasons of national security, competition, and so on. So it depends a lot on the partner, and we can all kinds of examples. So we can see 100% mutual liberalization with close partners like the EEA-AFTA states or with the Western Balkan states through the ECAA agreement, when the partners can invest or establish 100% subsidiaries mutually. But we can also see a case-by-case solution, for instance, in some Euro-Mediterranean agreements, when if there's a project, then it can be brought to the attention of the parties, and then they will decide on a case-by-case basis, which of course is a more uncertain way to approach this. And there are also some examples of gradual or conditional liberalization of ownership and control, for instance, with Canada and the United States, where legislative progress is a condition to go further. Also, when we look at airline ownership and control liberalization, we can say the Joint Committee may have an important role in regulatory cooperation in general, but also in some cases, like I mentioned, in a case-by-case approach. And finally, here we have to also mention or recall the importance of EU designation. So irrespective of the level of liberalization under the agreement, it's important that the partner states should accept the designation of any EU airline from any EU member state, because that was one of the core findings of the EU courts in the Open Skies judgments. Next one, please. So our next area is doing business, where again, the EU CATAs go a long way to open up opportunities for airlines. For instance, and there's a long list of areas here, they can open offices or other facilities in the other partner country. They can employ local or foreign staff. There must be freedom to select among ground handlers or even self-handling, non-discriminatory access to slots, the freedom of pricing and sailing tickets and other services. And there are lots of forms of cooperation between airlines are also explicitly allowed by these agreements. And that includes also aircraft leasing, especially when it's dry leasing, so without crew. When it is with crew, so wet leasing, there may be some more limitations for certain reasons. Next one, please. So fair competition or level playing field is a very important area, which is covered by the CATA. And this EU approach on fair competition is rooted in the integrated internal air transport market, where basically there are key fundamental principles. One is non-discrimination. Second one, the application of competition law. And third, the control of state aid. And basically, when the EU negotiates these CATAs, they try to base the negotiations on these fundamental principles. So if you wish, they try to kind of export the EU approach and experience with fair competition. It's very important because the EU believes that fair competition must go hand in hand with liberalization. So it's a kind of a condition, if you wish. That's why it becomes always a key subject in any CATA negotiation. And if we look at the agreements, we can also see that there's normally a special dispute settlement procedure on fair competition, which also confirms its utmost importance. Now, the problem is that internationally speaking, so at the multilateral stage, and I mean ICAO, there is a lack of definition of what we mean by fair competition. And so when the EU grounds such a importance to fair competition, it is important because when there's agreement, then basically through these CATAs, we are making some progress in trying to define what fair competition could mean or should mean in international air transport. And finally, it's important that once there's a fair competition article included in a CATA, then the EU would normally not need to use the defense instrument, which is currently the regulation from 2019, number 712. And this is a unilateral trade defense type instrument to be used in air transport. But once there is an agreement which contains a CATA, which contains fair competition clauses, then normally this instrument would not need to be used anymore. Next, please. Regulatory cooperation has also been mentioned, and I can only confirm the importance of this one. Why? For two reasons. One is that the EU also sees regulatory cooperation or convergence or harmonization, as you wish, as part of the fair competition issue. So basically saying or arguing that if we want to open up air transport, we should also want to make sure that there is at least a minimum harmonization of the regulatory framework for airlines and other operators. But regulatory cooperation under the CATAs is also a standalone issue in that it brings the two parties together to work together to develop their standards, basically, and how the standards are then implemented. It's comprehensive in scope, so it covers safety, security, air traffic management, environment, consumer protection, social aspects, and so on. So it goes very, very far, especially compared to, again, the baseline, which is the bilateral air service agreements. And institutionally, it is supported by the Joint Committee, which has a special task or role to oversee how the regulatory cooperation is going on the basis of the agreement. And I would emphasize here also that I believe this is an opportunity, a very good opportunity for the partner states, including ASEAN in the future, because there's lots of things that the EU can offer in terms of technical assistance, in terms of sharing experience, best practices, and so on. But of course, it's a mutual process. So what is important, especially for operators, is to have kind of a predictable framework from the regulatory point of view as well. Next one, please. Yes, so the next area I would like to mention is the institutional innovation in the CATAs, which is basically the establishment of a joint committee. This is not a concept which exists in the traditional bilaterals. And this comes from essentially EU association or cooperation agreements, where there was a good experience with that. The Joint Committee has a key role especially in administering the implementation of the CATA, and it ensures that the parties, so in this case the EU and ASEAN, will have continued engagement through meetings, so regular meetings, normally at least once a year, but also on an ad hoc basis whenever this is necessary to support the implementation of the agreement. There's a special role, as I mentioned, in regulatory cooperation, and also the Joint Committee has specific roles in dispute settlement, the fair competition provisions, and also sometimes in ownership and control liberalization. So this is a very important institutional innovation. Next one, please. And these are already my conclusions, which I could offer. First of all, I would mention that the EU approach to international aviation agreements or air transport agreements is based on the success of the internal EU liberalization of air transport, so the EU internal market, and lots of the concepts and approaches have come from that logic of the internal market. The EU in general follows a very liberal approach through the CATA agreements, both in market access, but also airline ownership and control, but with some conditions and sometimes through a gradual case-by-case arrangement to reach the ultimate goal of liberalization. The CATAs provide a very good framework for sustained cooperation, especially or including in regulatory areas. And what's also important is that they can evolve without the need to amend them. Again, unlike the bilateral agreement, air service agreements, which always have to be amended. If you want to change even the one frequency to be added, then we need to change the annex at least. And the CATAs have somehow in them this evolution already included. And I would say that, in my view, the EU comprehensive agreements have been a driving force in worldwide liberalization. Not alone, of course, we can mention the US Open Skies approach, but that was more traditional, so within the context of the traditional bilaterals. And I think the EU, after almost 20 years of negotiations, have put in place quite a few useful agreements which contribute to the efforts to liberalize air transport globally. Thank you for your attention.
Thank you, Máté. I mean, again, thank you very much for your interesting presentation, also on-time performance. So as you mentioned, for the next 10 minutes, Antigoni, me, and Máté will discuss our internal discussion. The three topics I want to discuss for the next 10 minutes is basically subsidy in the CATA, and then environmental aspect. And also last question is about any possibility of CATA, CATA to become sort of prototype of future air service agreement. So first question specifically, what's unique about CATA in terms of subsidy? Kind of background, as you know, the EU-ASEAN Air Transport Agreement, deep inside, strong motivation of this agreement is Middle Eastern carriers. Middle Eastern carriers have taken almost 50% of market share between the market between EU and ASEAN, and both parties wanted to emphasize that we want to do more. So fair competition, as Máté mentioned, has been really important consideration in this CATA. I just want to hear more from you, Antigoni and Máté, about what's so unique about subsidy in CATA. Can I ask Antigoni first?
Yes, so I agree with you, John, that the story with the Gulf Airlines and the allegations against the Gulf Airlines, the allegation that they distort competition, that they unlevel the playing field by receiving illegal subsidies from their governments, must have played a role in the negotiation of clauses on subsidies, on the control of subsidies in comprehensive air transport agreements. However, if one looks at the very first comprehensive air transport agreement, the one with the US, and in 2009, the agreement with Canada, especially in the agreement with Canada, there is a provision on subsidies, on the control of subsidies. And of course, this agreement predates the story with the Gulf Airlines and the white paper that came out major European and American airlines against the Gulf airlines. So I think the issue of subsidies and control of subsidies was on the agenda even before 2015. Everybody knows that the EU is the only trading bloc in the world that has a fully fledged state aid regime, which is enforceable. The European Commission enforces state aid control. The rules are well developed. They have been interpreted by the European courts in a myriad of cases. And the European Union arguably has an opportunity to export its state aid regime by means of these comprehensive air transport agreements. And it can achieve regulatory harmonization. And I think this can be a win-win. It's not just an imperial, I don't know how this sounds to third parties, maybe a little bit imperialistic, the EU exporting its law on subsidies. However, the reason why, if you look at competition law or antitrust law, the reason why we have regulatory convergence in competition law is thanks to legal transplants that have taken place. And we all know that we inherited antitrust law from the US. The US came up with the Sherman Act in 1890, and then the US exported its law. And thanks to legal transplants, we have regulatory convergence more or less in this area, and we are all on the same page when we discuss competition issues. I think third countries can benefit from the European Union by importing state aid law, which has been developed, interpreted by the European courts. The decisional practice of the European Commission is there. And rather than speaking of the European Union exporting its law and wanting perhaps to impose its law on third countries, we should see it as a contribution of the European Union to the world. I really see it as a win-win. The rules are in the public interest. There is full transparency. Everything is on the website of the European Commission. The courts have elaborated on the rules, so I don't see any problem with that. And I think I shouldn't elaborate further. I should leave the floor to Máté to complement, perhaps.
Thank you, Antigoni. Yes, I fully agree with what you said, but I would also argue that there is also an anomaly about state aid and air transport, in that air transport services are not covered by the WTO GATT rules, and therefore the subsidies regime, which is otherwise applicable in other sectors or in trade, I would say more in general, they simply cannot apply in air transport. So, of course, if we look back historically, WTO, there was an attempt to bring air transport under the rules, and also ICAO made an attempt to bring kind of subsidies, a subsidies regime to air transport. So they haven't been successful. So we do not have a multilateral framework on subsidies in air transport. So the EU, basically, if we simplify this, because of course it's a complicated policy area, said that, okay, we can go out and liberalize, but we need something in the absence of global rules. And what we can offer to negotiate is our experience. And as I mentioned, once there's an agreement, that's very useful, because there's kind of bilateral or mutual control of subsidies. And then neither party would need to use unilateral measures like in some other areas. So I believe that if we look at from the wider liberalization perspective, then the whole subsidies or state aid issue is of course complicated, but it's very, very helpful, because if there's an agreement on a framework, then it takes away much, if not most, of the possible concerns about full liberalization. Thank you.
Thank you. Thank you. Of course, we can talk more, but just to cover the three questions I wanted to cover in this internal discussion, I will move on to the next question, which is about CUHK. So ICAO adopted, carbon offsetting and reduction scheme for international aviation, so-called CUHK. And interestingly, I heard that in this CUHK, Corsia was specifically mentioned in this bilateral air transport agreement. So my question is, how can CUHK play a role in global greenhouse gas emission by aviation? Again, big question, but please share your view, please. Maybe Máté first.
Thank you, June. Yes, I would say that I would make a distinction between certain provisions within a CUHK, namely that there are what in some cases we could call like self-executive, provisions, legally speaking, when, to put simply, which are quite easy or more obvious to implement in practice. For instance, if we have third and fourth freedom fully liberalized, then it's quite straightforward. Then Lufthansa or whatever European airline can fly without restrictions to Singapore and the other way around. Now, if we have, and I give you an example, in the EU-US agreement, when it was amended, they added a clause on labor. And labor protection, it was something like this agreement shall not jeopardize the level of protection of the parties in the labor area, something like that. And of course, it's a legal provision, but the execution or implementation of it is much more difficult because basically it is like a reflection of a policy agreement or a commitment. And I would expect that the environment is a little bit like this because, of course, it's important to confirm the commitment by both sides. But when it comes to action, especially in ICAO, which is the multilateral framework or organization to deal with air transport environment issues, then it may not be more than this commitment in practice. So I can hardly see the CUHK to be used, legally speaking, to enforce or actually force the partner state to do that. Nevertheless, from the policy point of view, it's absolutely important to have these and other areas mentioned in the agreements.
Yes, and I agree with Máté, and I'm surprised that he made this comment because this is the comment I also wanted to make, June. But first of all, let me say something about the environment because somehow I get the feeling that people think that the contribution of aviation to climate change is enormous. And in Europe, we have the flight shame movement, and I cannot relate to it. And in my institution, I also had to sort of educate my colleagues about the contribution of aviation to climate change. There is ongoing research, scientific research. ICAO calculates the contribution of aviation at around 2%. The industry gives a figure 3%, 3.5%, and I was watching an interview that the Secretary General of Eurocontrol last November gave, who said that we have lost the PR battle in aviation because the public at large considers aviation a great polluter. Well, this is not the case. This is not the case, and I think that people who are experts in aviation and who have conducted research in the area of aviation and the environment, they must really educate the public and make clear that this is not an industry that pollutes very much. This is an industry at the cutting edge of technology. It is an industry that contributes a great deal to the development of green technologies, clean technologies. There is a lot of R&D and innovation that has gone into the fuel efficiency of the engines, into airframes, into biofuels, etc., etc. And instead, the public at large, even academics who understand science, think that aviation's contribution to climate change is 30%. Well, I'm sorry, this isn't the case. And now to come back to your question, I fully agree with Máté, and I read recently an excellent paper in the Annals of Air and Space Law, authored by Brian Havel and Eva Savage, where basically they they think that hortatory language in international treaties, such as a comprehensive air transport agreement, so agenda-setting language or aspirational language shouldn't be there. There is a place for such language in memoranda of consultations. There is a place for such language in explanatory notes, but certainly not in international conventions, which must be interpreted along the lines of the Vienna Convention on the Law of Treaties. So if somebody wants to read this paper, this is one of the best papers I read in the past year, I think. And it is published in the Annals of Air and Space Law in 2019. And it is against hortatory language in treaties. And there is reference to the case that Máté mentioned before a US court, where the court had to interpret Article 17 bis of the EU-US air transport agreement. And the court said, well, I'm looking at this provision, but it doesn't create any binding obligations. So I cannot possibly enforce the provision. So with respect to the environment, I was looking at the EU-Qatar air transport agreement, because there is their reference to CORSIA also in the relevant provision on the environment. There is one shall, but then if you look at the rest of the language, it demonstrates the intention of the parties, the goodwill of the parties, but it doesn't really create binding obligations on the parties. So from an enforceability point of view, I don't know where we stand with this sort of provisions.
Okay, thank you. Because I promised that we are going to have a Q&A session, I'm going to skip my last question. But just one thing I want to add is the environmental aspect is that, so CORSIA eventually SARPs annex to Chicago Convention, and states can have the choice, opt out those annex, even if it goes to annex. So I think the way I see it potentially is that, well, I agree, language is quite weak, but putting this CORSIA provision in the bilateral air transport agreement, maybe it could create more power rather than multilateral scheme, which can be opted out by the member states. One thing I want to add it to what you said. Okay, so over to you, Antigoni. I note that we have some questions from the chatting, so please moderate and you conclude. So now, yeah, please, over to you.
Let's see in the chat what sort of questions we have, and then we can open the floor and people can unmute themselves and pose the question. So I can just see one question here, and perhaps when we tackle this, if nobody from the floor wants, in the audience wants to pose a question, perhaps June, we can go back to your third question. So question for the speakers: what, according to you, will be impacts of COVID-19 pandemic and Russia-Ukraine war on the future of EU-ASEAN air transport agreements? Thanks. Thank you, Shmuel, for this question. So let's focus on COVID-19 first. What will be the impact of COVID-19 pandemic on the future of the EU-ASEAN air transport agreement? So I'm wondering whether any of you would like to take this question.
Okay, maybe I'll just go start. I mean, how COVID-19 affected EU-ASEAN agreement is actually, of course, a negative one, because EU-ASEAN was about to conclude, but because of COVID-19, they couldn't meet up. And then the even signature ceremony was done by Zoom online. So that's the reality. But I think COVID-19 gave a lot of questions which airline industry didn't really think much. So I don't think anything can be added in the substance to Qatar. So really, I'm not answering your question, Shmuel, but that one, COVID-19, it's in terms of substance of Qatar, I don't think I don't see any substantial update in this agreement. The Russia-Ukraine war, although it's creating a lot of questions, not just aviation law, of course, really various types of law. In fact, last week I attended IQ legal committee. This issue was fully discussed, although it was not agenda. But if you ask me, particularly EU-ASEAN air transport agreement, I can't really think of a particular one. I mean, if you ask me, maybe EU Northeast Asian agreement, I say EU, Korea, EU, Japan. there are some relevance because you need to fly over Russia. Many EU ASEAN transport, you don't need to go over Russian territory, or you can easily deviate the route. So impact of the Russia-Ukraine war to EU ASEAN aviation market is not that significant. It is significant, but compared to other regions, I would say less significant. Máté, please.
Thank you, June. Actually, I fully agree with what you said, including on the Siberian overflight question, which has become, of course, an issue because there are much longer now flight times and all that. Maybe something I would add is the price of fuel, because that is always a very important question in aviation. And there is certainly a high degree of uncertainty for the time being. I mean, I'm sure it's the same if you go to tank your own car, you see the difference. And I would say that it would be unfortunate if having this very good framework between the EU and ASEAN, the problem of fuel, any similar issue would kind of slow down the growth, because basically this framework is there to support the growth of the air transport between the two regions and maybe beyond. So I think this question of uncertainty is relevant for the whole air transport industry, and I am not sure we can see at this moment all the implications. We can only hope that first of all the war be over soon, as soon as possible, hopefully, and then after that air transport can go back to normal, and we can all benefit from this agreement and anyway the normalization of air transport. Thank you.
Thank you both for your answers, and I cannot see another question in the chat, so then I will invite the participants to pose their questions. Just unmute yourself and pose your question, if you will. No questions?
Antigoni, maybe while we are waiting for a question, can I ask a question I wanted to ask?
There is one, actually. There is
okay,
one. So Mustafa just posed the question. My question is about the competition aspects of collaboration between airlines. Could you please scrutinize co-chair agreements and alliances in terms of competition concerns in a bit more detail? Collaboration between airlines, co-chair agreements and alliances, and whether they raise any competition concerns. Does anybody want to take this question? Or...
Yeah, let me try. Of course, I need 45 minutes to fully cover the subject, but in a nutshell, let me just elaborate. Alliance is basically any form of contract between airlines. So we use term alliance in a very ambiguous manner. Simple level of alliance doesn't really create competition concern. We're talking about sharing lounge or interlining, put my baggage. So please, can I go to Ecuador from Hong Kong? But when I go to Ecuador, I need to go to multiple destinations. Then the airline must work together in order to transfer me to Ecuador. That doesn't create any competition concern. But if you start to share some sensitive information, let's say capacity, price, then it could create competition concern. If you want to do more, if you want to share revenue, if you want to work as if one company, that could create competition concern. In that case, you need to get immunity from your respective government. So in a nutshell, not all alliance doesn't create competition concern. Only high degree of alliance could create competition concern. In that case, you need to get a immunity, or need to deal with competition law in your domestic jurisdiction.
Right. So June, you wanted to pose a question as well?
Yeah. So one thing, the last question I wanted to ask is maybe a broader could be almost academic philosophical question. So as we all know, air service agreement, very first air service agreement was adopted 1946 between United Kingdom, United States, after the state failed to have multilateral agreement in Chicago, 1944. So this Bermuda Air Service Agreement, 1946, has become kind of prototype of the following nearly 4,000 bilateral air service agreement. Yes, they have been added, but if you look at the structure, really nothing has been changed dramatically. So as Máté mentioned, as Antigoni mentioned, this kata is really comprehensive. And we're not just looking at block to block structural aspect, we're really looking about the comprehensiveness of those agreements. So my question to you is that, do you think this kata has a potential to become the prototype of future air transport agreement or air service agreement? That's the question.
I think more than that, you are not very ambitious, June. I think it has the potential to reach liberalization of international air transport. I think this is the impetus behind these agreements. It's not just about becoming a prototype for the 21st century. It is also about liberalizing international civil aviation, and to the extent that you have block-to-block agreements such as the EU-ASEAN, where 37 countries achieve regulatory convergence in very many areas. And then you have the same countries entering into similar agreements with other third countries around the world. I think it embeds a degree of de jure liberalization, and de facto also, because airlines will have to compete on that playing field that is created by means of these agreements. So I think that the comprehensive air transport agreements that the European Commission has conceived have the potential to liberalize international civil aviation. Incrementally, it is an incremental process, but we are used to that in aviation.
If I may, on this one, I agree, and I would also add that when we look at liberalization, the context, it's important that ICAO has been working on this for a long time, and I had the pleasure to support this work, and I hope it will somehow be revived, but for the time being, at least, it doesn't look like we will have a global liberalization framework in the short term, at least. So that means that we are back at the bilateral or regional level, and I believe that the EU-ASEAN kata will contribute to that. At the same time, as I said, it's more an evolutionary approach. So I mean, the result of this is a result of many years of EU external aviation policy, negotiations with different states, and these states have heavily influenced, of course, the outcome. So I would say it's important indeed, because you know, the more states are partnering with the EU and then maybe with each other, the more this type of approach you will see, hopefully. And I would also add that when we look at the impacts, we can of course look at the states, how many states have liberal agreements and so on. But I think it's also important to look at the figures, because if we combine ASEAN and the EU, we will see, I don't have the figures at hand because now after the COVID, it's difficult. But if we look back, I mean, a big chunk of air transport is between these two blocks. And if we add, you know, some other agreements to this one, like the EU-US, which is liberal enough, and so on, then we will maybe end up with a surprisingly high number of, or high portion of the world air transport market, which is already quite liberal. So I think there's lots of progress being made, maybe not formally at the global level, but I think we are getting there, and that's very positive. Thank you.
June, would you like to contribute also your own view, or shall I go to yet another question from the floor?
Yeah, so I think you both Antigoni and Máté explained from more European perspective that what I am expecting is that ASEAN would probably like to use this agreement when they negotiate with other partners. So I can expect that when ASEAN is negotiating with Korea, Japan, India, the current negotiating partner, I think their experience with the EU will play out. Some of the clauses they signed with the EU can be added in their future agreement. So I agree, it's not going to be revolutionary change, but somehow it will go to different places.
Right, and there is one question, which is, what challenges and or opportunities does the ASEAN-EU Comprehensive Air Transport Agreement bring to Hong Kong? Challenges and opportunities of the agreement between the EU and ASEAN for Hong Kong. I think, June, this is for you.
Yeah, because of the fact that I'm based in Hong Kong, I'll explain. But one thing I want to say is that, you know, if you look at the ASEAN-EU market, Hong Kong is not really deeply related because geographically, I'm talking about geographically. If you ask me ASEAN-US, let's say there's an agreement, Hong Kong will be deeply affected because a lot of traffic happening from ASEAN, US via Hong Kong. Hong Kong is geographically located in between. But if you look at the ASEAN-EU, not really. Of course, the one who will be deeply affected will be Middle Eastern carriers, and including Turkish carrier, because they are the one who has been really big fish. Like I said before, about 50% of market share was done by those carriers. But I have to mention that agreement itself doesn't create traffic, right? Agreement is just agreement between government. Eventually, it's up to airline to maximize the benefit coming from those agreements.
Right. I don't know if Máté would like to contribute anything to this, to answering this question about Hong Kong in particular, Hong Kong being very liberal, as I understand it, together with Singapore, isn't it? Okay, so
yes,
any other question?
Yeah.
Yes, Máté.
No, I think other than that, what June said, that this could be an example, and also because the weight of the partners, I'm sure that this agreement will be well known and maybe could serve as an example in certain areas.
And perhaps at some point in the future, we could see a comprehensive air transport agreement between the European Union and China. I know we're not there yet, but hopefully we will see that at some point. Let's see. I'm being very ambitious now, overly ambitious. And it is 11:30 almost here in London. I believe it is 6:30 in Hong Kong. So I would like to thank Máté, who made time for this webinar today. Thank you very much, Máté. As I said before, Máté spoke in his personal capacity, so the Commission is not bound in any way by what he said, but to us, his insights are important given his experience. I would also like to thank my good colleague, but primarily good friend, June at the Chinese University of Hong Kong, who conceived this idea of an EU-Asia Aviation Law Forum and who had the idea of launching the forum by discussing first the EU-ASEAN Air Transport Agreement. So June, thank you for this brainchild of yours that we have all adopted by now, I hope. And I would also like to thank our attendees here in London, in Hong Kong, in Brussels and beyond. Sign up to our university's newsletters to stay in the loop. And have a good weekend now, and see you next time.
See you next
Bye,
year.
Thank you. Bye-bye.